Hi, my name is Carl Pearson. I'm an attorney helping clients throughout the United States save their homes from foreclosure. This is my video number 124 entitled Loan Modifications, Foreclosures, and Keeping Your Home. Most homeowners who have lost their homes since 2009 have done so needlessly. Loss could have been avoided if the homeowners at the outset of their problems had and acted on the information and analysis I'm about to provide. Remember, I'm not saying that everyone would have saved his or her home, but I'm sure, based on what I know, that a high percentage of the persons who lost their homes could have prevented this loss, but didn't know this and didn't know what to do or through whom to do it. I want to make sure you understand what I'm saying, so forgive me for going into some basics. The first is, quote, judicial foreclosure, unquote, which refers to the type of foreclosure taking place in 22 states where the bank or servicer or the note owner or investor files a summons and complaint in a local court asking the court for permission to foreclose and sell the property. In these states, known as the judicial foreclosure states, including New York, Florida, and New Jersey, the homeowner has far more opportunity to stop a foreclosure by hiring a competent foreclosure defense attorney and responding to the complaint with a timely answer with affirmative defenses and possibly some counterclaims. And at the same time, using a competent, highly skilled loan processor to prepare and file with the plaintiff's attorney, who then sends your application on to the plaintiff, a loan modification application seeking an affordable loan modification agreement under a loan modification program appropriate to the homeowner. The attorney's work is designed to let the plaintiff know that the homeowner is prepared to fight legally to keep his or her property and to prevent a default in the litigation, which encourages the plaintiff and its attorneys to consider your loan modification application more carefully and with greater respect than they might do otherwise, because only through granting an affordable loan modification agreement would the plaintiff be able to end the lawsuit and more quickly bring the mortgage back to a performing status. If the plaintiff doesn't grant an affordable loan modification agreement, the lawsuit will become costly to the bank and, of course, to the homeowner to a lesser extent, and tend to destroy the value of the plaintiff's note and mortgage through costly legal fees, litigation expenses, and continued non-payment of the mortgage, together with the amounts that the plaintiff will be laying out for real estate taxes and insurance to prevent destruction in value of the mortgage property through tax liens and fire or vandalism. The importance of having the right attorney to represent the homeowner cannot be understated. I actually meant, of course, overstated, cannot be overstated, nor can it be overstated how difficult it is for most homeowners to find a suitable attorney in their county within their judicial foreclosure state. There are 3,100 counties in the 50 states, and there seem to be very few attorneys willing and able to take on this type of work, for many good reasons which I'll try to explain in summary, which will show you why it's difficult to obtain an attorney. Homeowners looking for a lawyer are generally unsophisticated as to their rights and the laws relating to foreclosure and loan modifications, and many homeowners are burdened with false information about foreclosure defense that makes things even worse. It takes an hour more or less to speak with someone about their case before even looking at the extensive documentation that goes along with a foreclosure. And most attorneys who could, if they desire, do this type of work have not chosen to do so because of the many hours spent talking with prospective clients without compensation in order to find a few clients who basically have no money, have a lot of problems, and do not represent any repeat business, but representing a type of client which could cost the law firm or attorney to lose clients representing repeat business, such as banks, other financial institutions, and purchasers of notes and mortgages, to name a few types. The first problem in finding a suitable attorney requires that you understand that problem. First of all, foreclosures and any commercial litigation is too difficult for the typical owner to try to represent himself pro se, or it may be called in pro per. To try this, as millions have found out, the result is to lose your home. It is too difficult. Your knowledge and experience is not good enough, and the judge is not allowed to be your attorney during this litigation process. Instead, you need to find a local attorney because of the requirement in your county court system that the attorney representing you in any lawsuit must be a member of the bar in your state, and possibly some additional licensing required in your county. I, as a member of the bar in New York State, have been given pro hoc vice status in various lawsuits in states outside of New York to represent the client in a single action, but this is not necessary and is too costly and could have an adverse effect on your local judge, who might not be as judicially tempered when listening to the arguments of an out-of-state lawyer. Also, there could be a terribly high cost to the homeowner, amounting to several $1,000s in time and travel expenses if I had to travel to a distant court to speak with a judge for 5 minutes. The way to obtain the representation you need is to retain a local lawyer, preferably a commercial litigator, even if such person has no foreclosure defense experience, assuming you can't find a suitable foreclosure defense attorney in or around your county. Or an experienced civil rights litigator who, because of more demanding federal lawsuits, is probably highly qualified to represent you in the foreclosure action with assistance from a competent foreclosure defense attorney from outside of your home state. This combination is the way of getting the legal assistance you need. A local attorney to file your papers and represent you in the local court proceedings, and an experienced foreclosure defense attorney from outside of state to review the summons and complaint and other relevant documents, including the assignments of the note and mortgage, your loan modification and bankruptcy history, your financial affairs, and other relevant matters, and to oversee the preparation and filing of your loan modification application, which needs to be prepared and filed by a highly skilled loan processor, and your answer with affirmative defenses and any counterclaims, the most important thing for you to have done timely and as well as possible. We need to talk about the loan processor. It is of the utmost importance, and too often is the reason for a person losing his or her home, because the loan processor being used was not highly skilled. You must use a skilled loan processor. Now, let me give you some background discussion about loan modification businesses. The problem involving loan processors is complicated and dates back to 2008 or so, when a lot of foreclosures started. Loan processors have been unregulated, unlike attorneys. And when real estate sales and the mortgage market collapsed in 2008, many persons shifted to other pursuits, including the preparation of loan modification applications. Comparatively large sums of money were taken in advance by persons who didn't know what they were doing, and also the banks were less willing to give loan modifications at the beginning. These loan modification companies, almost all acting outside of any law firm, and without the supervision and input from an attorney, and not required to be licensed, became subject to federal and state legislation prohibiting them from taking any money in advance, and were required to do their work on a contingent fee basis to get paid only if the homeowner got a loan modification. This new arrangement, required by law, put many of these firms out of business because they could not operate on a contingent fee basis. Homeowners who couldn't afford their usually too costly services would often do the loan modification work themselves, and more homeowners did so after many loan modification companies went out of business because of the new statutes. During this period, courts in various states began setting up mediation opportunities for trying to keep troubled homeowners in their homes, and attorneys became more involved, and out of necessity were involved to an extent varying from lawyer to lawyer in the loan modification application process. But unless the lawyer devoted most of his time to processing loan modifications, and the regulations, the software and technicalities involved in loan processing, and were not able themselves to know when the bank was making any errors when denying a loan modification application, or was coming in with too high an amount of monthly payment and or principal amount of mortgage in an offered loan modification agreement. Without being a loan processor, it's difficult to understand everything that's going on if your skill is litigation. Processing loan modification applications can involve legal matters and should have an attorney reviewing and supervising and performing legal work where necessary, coordinating with the skilled loan processor to give the homeowner the best chance of obtaining a loan modification agreement and obtaining one which is the best obtainable, including a possible principal reduction and a possible waiver of the arrears. If a law firm or lawyer tries to defend against foreclosures without having this type of loan processing service available to the client will probably have a significantly reduced chance of obtaining an affordable loan modification and saving his or her home. Loan processing companies are not alone in having problems. There are other types of people involved in this industry, and let's talk about a few. Many, but now fewer companies or individuals offering securitization audits are charging substantially more than the audits are worth to the homeowner. The offered affidavit testifying as to title to the note or mortgage is of no value. The person's opinion won't be accepted by any judge in the same way the judge would not accept my opinion as a lawyer on the title. The judge will listen to my argument and then make his decision or opinion of who has title, but will not accept the affidavit as evidence of title because of the opinion of some real estate person saying that he believes that that title is not with the plaintiff. At best, the affidavit will provide evidence of recorded assignments, the existence of which are probably not in dispute and would be contained in the summons and complaint, and perhaps identify the trust which claims to have ownership at some point of the note and mortgage. But that limited information is hardly worth the thousands of dollars that people often pay for a loan securitization, a securitization audit. Real estate lawyers tend not to litigate, and they are often unwilling to sue a bank because the real estate lawyer is constantly trying to obtain money from banks for his land purchasing clients. Bankruptcy lawyers are a problem because most of them will not commence the needed, quote, adversary proceeding, unquote, for the bankrupt, which means that the bankrupt will be admitting the validity of the bank's note and mortgage, which is a very, very bad thing to do in foreclosure defense, unless you are settling the case with an affordable loan modification agreement. Some lawyers say they are willing to defend the homeowner for, say, $750 a month, as long as the case lasts. But this type of arrangement is not likely to result in any affordable loan modification agreement because the agreement would terminate the monthly payment of $750 received whether the attorney does any work or not, with the passage of time making it more difficult for the homeowner to obtain a loan modification agreement, with the end result often being that there is none and that money was wasted. The solution: to qualify for an affordable loan modification agreement, many homeowners need to deal with legal issues involving bankruptcy, credit card debts, second or third mortgages, deceased relatives, tenants, outstanding judgments, other encumbrances on the title, unpaid tax liens, tax issues, a new job, a new business, projected income, cash payments, partnership and corporate interest, preparation of an answer to a complaint, seeking discovery, possibly making an order to show cause to stop a threatened sale, and so on, which requires a lawyer's input. Working with a loan processor, resolving one or more of these problems may qualify the homeowner for the desired affordable loan modification agreement. If the homeowner retains that needed team through hiring of an appropriate foreclosure defense lawyer, even one located out of state, the homeowner will have the best chance of saving his or her home. Remember, that's really the important part of this, that you need a lawyer who knows what he's doing together with a loan processor who knows what he's doing, and this can be from out of state, and it often is the only choice that people find. So I'm pointing that out. Government programs, which I'll identify later, were enacted in 2008 and 2009 and after to help homeowners, but the banks and investors still resisted homeowners' efforts to save their homes, which resulted in the Justice Department and 49 state attorneys generals suing the main banks and loan servicers, and on February 9, 2012, getting a national settlement agreement which made it better for homeowners in default to obtain a loan modification agreement. The holdout Oklahoma Attorney General entered into a separate agreement. As a result of this settlement agreement, the banks and their servicers have to comply with about 305 additional mortgaging servicing rules spelled out in that agreement. As almost every homeowner in trouble at one time or another knows, the amount of information required by the owner of the note or its servicer is substantial and varies from one matter to another, including the amount borrowed, the value of the home, the amount owed, the type of property involved, residential or commercial, 1 to 4 unit residential or more than 4 unit residential, the hardship involved and the type of loan program involved, HARP, HAMP, FNMA, Fannie Mae, Freddie Mac, Ginnie Mae, Hurricane Sandy related programs, even in-house modifications or other programs. It's complicated, very complicated. HAMP, enacted in 2008-2009, is to help defaulted mortgagors through a loan modification agreement, an affordable one. And HARP, which is 2009 for HARP 1, is to help underwater homeowners who are not in default to obtain lower interest rates through a refinancing, which can't take place because there isn't any equity for the new bank to come in and grant a loan the way it normally would. So HARP then provides the basis for a bank to come in even though the property is underwater, and provide a refinancing to lower the amount that the homeowner is paying where he isn't in default. HARP, by the way, is scheduled to expire at the end of 2015, December 31. There are rules and regulations relating to the various loan modification programs. There are various regulatory agencies involved with opportunities to complain and to appeal, but the loan processor needs to know all this and to know when the plaintiff, a servicer, securitization trustee, a bank, an investor, a vulture fund, or other owner, is making a mistake, and how to force the plaintiff, which is trying to take the property away from the homeowner, to correct the mistake and thereby prevent the plaintiff from losing the property, the plaintiff from taking the property. Most loan processors do not have the needed skill or experience to do the job properly. Some of the matters overlap with legal issues, and loan processors generally are not attorneys, so that loan processors not working with an attorney or an experienced foreclosure defense attorney may fail to see material legal issues or deal with them properly. Also, loan processors not working with an attorney will tend to have less credibility with the plaintiff because of this gap in legal awareness and skill. If, however, the homeowner is working with a highly skilled loan processor and an experienced, competent foreclosure defense attorney, the homeowner has the right combination of skills to help the homeowner maximize his or her position. Remember, I'm not saying that this combination guarantees success, but it is more apt to get you what you are entitled to than any other combination I know. When a homeowner is being threatened with the loss of his or her home, the homeowner needs to face this problem earlier rather than later. Very early after the crisis started in 2008, I saw the need for homeowners to look at mortgages differently than they were doing, and prepared and shot a video, my first foreclosure-related video, entitled "Stop Paying Your Mortgage." This still applies for at least 2 reasons. You often need to be in default for a bank to consider giving you a loan modification agreement, the bank saying, "Why should we reduce the amount you promised to pay as long as you continue to pay the amount? Obviously you can afford to pay the amount because you continue to pay it." Of course, this is fallacious and self-serving. Some distressed mortgagors have probably robbed gas stations or committed other crimes to raise the money to avoid losing their home. The second reason is that when you see you're going to have trouble in future months paying your mortgage, you need to retain the professional services of a competent foreclosure defense attorney and highly skilled loan processor. And if you have given all of your money to the bank, you'll have no money left with which to save your home. So stop paying your mortgage at a point before you become unable to pay for the professional help you will need to save your property. You need to set aside embarrassment and the thought of losing your credit rating, because this is your home and that is at stake, and you have a financial hardship requiring you to stop paying your mortgage and get, as a result, a reduced credit rating so you can get the needed relief and save your home. I hope what I have just said helps homeowners who are in judicial foreclosure states. For homeowners in the non-judicial foreclosure states, which is in the majority, 28 of them, with California and Nevada being the most prominent, what I said above applies to a great extent, except you do not get the luxury of a lawsuit to defend, which can often allow you to stay in your home for years. My longest case is 14 years without the homeowners paying their mortgage, a most unusual situation, I should add. Instead, your time to do something after you are in default in a non-judicial foreclosure state is very short indeed. Let me explain the word default. I've used it previously, but please keep in mind that word. It has two distinct meanings. The first to come about is a default in paying your mortgage, or in the non-judicial foreclosure states, the mortgage is usually in the form of a deed of trust, which is where the problem arises. A default in paying the mortgage may arise upon failure to timely pay any mortgage payment, a very stringent mortgage provision, or upon non-payment of the second or third monthly payment, as well as the mortgage or deed of trust spells out. When this defaulting non-payment occurs, the owner of the note or its loan servicer will issue some type of default notice under the law of the homeowner state and advise the homeowner that unless the homeowner cures the default within a certain period of time, or worse, pays the full amount due, which is an acceleration of the loan so that the full amount of unpaid principal becomes due together with the arrears, something which most homeowners could never pay, the bank or servicer, through its trustee under the deed of trust, will sell your home at auction in 60 days or so, the number of days differing according to the state and the activities by the owner and the trustee under the deed of trust. The second type of default is when a homeowner in a judicial foreclosure state fails to answer or make a motion to dismiss the summons and complaint on a timely basis. This type of default will prevent you from defending the action without costly and often unsuccessful motions and appeals. So whatever you do, please never be in default in a foreclosure action. It is almost criminal neglect for you to be in default. You lose so many rights when you're in default. Because in a non-judicial foreclosure state there is no foreclosure action to defend, the homeowner should do the following to protect his or her property from foreclosure. 1. Retain the outside attorney who handles foreclosure defense and the related highly experienced loan processor. And 1. Take advantage of any loss mitigation mediation procedures available in your state or county. 2. Apply for a loan modification. And 3. Consider whether there are any grounds for filing a lawsuit to try to obtain an injunction prohibiting sale of your property if the sale is threatened a short time away. You would not need to do this unless the scheduled sale date is less than a month away, because you probably won't be able to complete the loan modification process within that 1 month or less period. But you need to remember, and there is also a 37-day rule, that if you have your application completed and submitted at least 37 days before a scheduled sale date, they don't have the right to sell the property. That's just something to remember as a side note here. But you need to remember that an injunction action probably will not prevail if all you have is a belief that the bank or servicer does not have possession of or title to the original note. Instead, you would want to base your injunction action on some type of breach of agreement by the servicer or note owner. I do not recommend seeking an injunction when there is little or no basis to do so, because it generally will fail and you will be and you will lose the money you spend to make that futile effort. Instead, you will want your team to explore all avenues for you to obtain a loan modification agreement, including any state or county required or optional mediation. As to this mediation activity, the homeowner may wish to use a local attorney who probably should have the ability to litigate, such as a commercial litigator or a civil rights litigator, to ensure that your rights are being protected. There are loss mitigation options that need to be reviewed in addition to the desired option of a loan modification agreement, and the use of some of these other options can involve the legal issues for which a lawsuit could be employed, not for the real purpose of obtaining the secondary loss mitigation option, but to encourage a note owner and its servicer to give you an affordable loan modification agreement so that you will drop your lawsuit in that non-judicial foreclosure situation. In summary, whether you are in a judicial foreclosure state or a non-judicial foreclosure state, if you are financially distressed and threatened with foreclosure of your home or investment property, 1 to 4 unit, you need the assistance of 2 skilled persons working together, consisting of an experienced foreclosure defense attorney and a highly skilled loan processor who works with such attorney. For any local court or mediation activity, you will also need a local lawyer who is willing to work with the other 2, and after a while will probably want to retain his or her own highly skilled loan processor and represent local clients without the help of an out-of-state attorney. It should be noted that the local attorney has nothing to fear. He or she will be able to draw upon the skills of the outside attorney to whatever extent is needed, which will enable the local attorney to gain valuable experience and sooner or later start taking on foreclosure clients without any need of outside legal help. If you have any questions, please give me a call at 212-307-4444. My rates are reasonable, and I probably can help you see how to solve your problem of obtaining an affordable loan modification agreement and the related problem of not being able to find a suitable attorney. Remember though, of course, there never are any guarantees. If any friend, relative, or associate of yours is having a foreclosure or loan modification problem, please email to that person a link to this video and your comments about the video. I know this is a lot of material, and I'm preparing an e-book based on the text of this video, including additional information, which will be made available for a nominal charge through Kindle, Nook, and other places for acquiring e-books. My number, once again, in New York City is 212-307-4444.